Welcome, Christopher Barnewalt. I think I said that right.
You did.
To the Wellness Law Podcast. Everyone, I want you to meet Christopher. He is an attorney with the Pacific Legal Foundation, which is a public interest law firm that has been suing the government since 1973.
That's right.
And he was previously at the Cato Institute. And the focus of the Pacific Legal Foundation and what Christopher does as a lawyer for them is on protecting individual liberties. He can go into a little bit more detail about what that all means, but he is on the equality and opportunity team. And the reason why I have brought him on to the podcast is because he is one of the attorneys that is involved in a lawsuit in California, which I have talked about on my blogs and previous recordings, the Anna Runkle v. Leah Tate case. And this is a case of the crappy childhood fairy who was being disciplined by the California Psychology Examining Board for basically coaching. Coaching is such a broad term. And so we want to talk about that case and the work that Christopher does through the Pacific Legal Foundation. So welcome, Christopher.
Thank you so much for having me on, Barbara. It's a pleasure to be here.
I'm just, I can't tell you how thrilled I am because, as I mentioned before we hit record, I've written a couple of law review articles on this very topic of First Amendment free speech protection for unlicensed individuals like coaches and overbreadth of practice acts, occupational practice acts like the Medical Practice Act. And in the case that you're doing in California, the Psychology Practice Act in California. And so I guess my first question to you is why did you guys bring this case?
We brought this case to stand up for individual rights, and especially here, the right to talk, the right to have conversations, the right to give advice and guidance to people without needing permission from the government first. What's happening here is Anna Runkle, who goes by the affectionate name Crappy Childhood Fairy in California, is she put together a life coaching business based on her own personal experiences. She had something of a less than optimal childhood. I won't go into the whole issues, but there were problems with addiction in her family, and that left an impact on her later in life. She struggled professionally, she struggled personally, and in her own relationships. She went to many different therapists, but traditional talk therapy never ended up working for her. She did eventually find through friends certain techniques which helped calm her emotions, helped get her in a better place, helped put her life together. And what started with informal conversations for friends eventually turned into a business. There was great demand to hear what Anna had to say, sharing her personal experiences and what worked for her. And so she turned it into the Crappy Childhood Fairy business. She has YouTube videos. I believe she has over 1 million followers. She's published some books. She has a website and a blog. And she also has paid coaching lessons for people who are interested in that. Uh,
Yeah. I
been
see
very,
she
pro-
also does large group webinars and small group coaching services too.
yes, that's right. So she's been doing this since 2016. And there's been no incident until one individual in Maine complained in 2023 to the California Board of Psychology. And now Anna has always been totally upfront with who she is, what she does. She always says that she is not a psychologist. She's not a therapist. She's not a medical professional. And if anybody needs a medical professional, then they should reach out to them. She always puts that up front on her website and as a disclaimer whenever she does her paid coaching with anyone. But the California Board of Psychology decided that what she's doing counts as the practice of psychology without a license. So this year they decided to discipline her. They did a final order saying that she has to pay a $2,500 fine and cease all practices which require a psychology license.
Wow. Can I ask the person from Maine who complained, were they another practitioner or were they a client of hers that
I believe that this person was only in one of the free events. They were not a professional, and this person wrote to the Board of Psychology complaining about Anna.
just, I assume it would be great to get that complaint, but I assume the complaint was along the lines of this person is practicing psychology and they without a license. I mean, I can't imagine if they were attending a group session that there would have been some harm of some sort that
Yeah.
occurred.
And the complaint didn't allege that they were harmed. She
Yeah.
just said this person is practicing psychology without a license.
Yeah. That actually is the first time. If you read the Del Castillo case out of the 11th Circuit, where Heather Del Castillo is a nutrition coach, and I think this was the case, maybe it was a different case, but there was a case where a nutrition coach was giving a seminar, like a group seminar, and someone in the audience was in attendance, and basically they were just doing their own investigation and decided that this nutrition coach was practicing dietetics without a license, and so they complained to the licensing board. It might have been a different case. It might have been one in Ohio or North Carolina. I can't remember. It might have been the Cook Seafood Beef Futrell case, but one of those cases, similar setup where an attendee of a webinar or seminar by this coach thought that the person giving the seminar was acting like a unlicensed health professional of some sort and made a report to the licensing board.
It's a real problem in many areas, this kind of attitude that if you don't have the right paperwork and if you talk about the wrong things, then the government's going to come after you, even if there hasn't been any harm to anybody, even if nobody's ever been deceived or put in any danger. It's this very formalistic and un-American attitude that you need permission from the government in order to talk about certain things. There was actually another case that we completed recently at Pacific Legal Foundation in Kansas in the nursing field with a lovely woman named Amy Seipel. She had been a nurse without incident for over 30 years. For a brief period of time, her license lapsed when she was taking care of her husband who had become diagnosed with cancer. She renewed her license, her nursing license afterwards, but the board of nursing in Kansas decided to investigate her, and they found that because her website said she was a nurse practitioner when her license was lapsed, and because she had spoken, she'd given some talks about dementia, that was the unlicensed practice of nursing, and they came after her for that as well. Now, we recently did vindicate Amy. Actually, the Kansas legislature vindicated her. They heard about her case. Apparently, there were many other Kansas nurses who had been forced out of nursing by the board, imposing very draconian penalties when no patient was ever put at any risk for harm, just forcing experienced people out of the healthcare workforce because of this focus on kind of the minutiae of did you have the right paperwork at the right time.
Yeah. And at a time where there's such a shortage of healthcare workers and people who can provide the services that consumers want and need, patients want and need, it just seems really draconian, as you said. Wow. So
It
that,
it doesn't make sense because the justification for this sort of heavy-handed government action is supposedly to protect the public. But you're not protecting the public. The public are the ones who are benefiting from nurse practitioners like Amy or are benefiting from life coaches like Anna. They're the ones out there who benefit. They're not being harmed. There's not even an allegation of harm. It's just
right.
the government coming in and saying, you didn't get the right permission slip from us, and therefore we're going to impose serious consequences you in your life. The government is getting in the way of public health and public wellness in these areas.
Yeah.
At Pacific Legal, we push back against that. We try to get the government to go back into its lane.
Yeah. That's really encouraging to hear. One question about Pacific Legal Foundation in particular. Do you guys take cases throughout the United States, or are you focused on it sounds like you do, but I just wanna confirm that's
We do. We have clients throughout the United States. We are a public interest law firm. We represent our clients pro bono at no charge, and we sue the state government whenever we find that it is violating constitutional rights.
yeah,
And in the case of Anna, we have a very powerful tool, which is her constitutionally guaranteed right to freedom of speech, which
yeah,
the Supreme Court, in the healthcare context, in the context of licensure, has reaffirmed again and again with cases like NIFLA versus Becerra and most recently Childs versus Salazar.
yeah, and the First Amendment free speech clause is a really powerful tool. And I'm so glad that you guys are bringing this case. And I'm hopeful that are you in the Northern District of California?
Yes, we are.
I don't know that they vote, create a law that's in your favor or a decision that's in your favor and Runkle's favor. Because I'm reading the definition of California's definition of this practice of psychology, and it is very broad. It includes intervening to increase effective functioning of individuals, groups, and organizations. That if you intervene to increase effective functioning of individuals, groups, and organizations, you are technically practicing psychology. That captures not only people like Anna Runkle who are life coaching, but what about business consultants? If you're intervening to increase the effective functioning of an organization, isn't that why you're hired? You're a business a consultant through Deloitte or Ernst& and Young or Price Waterhouse, all those big consulting firms. How are they not practicing psychology under that definition?
That's absolutely right. 100% agree. That is a big part of our complaint in California, which is the definition of psychology. It's overbroad, it's vague, it's circular. It doesn't make sense. It applies to practically anything, really. You were quoting from it. I believe the definition says that the practice of psychology is rendering or offering, like you said, to individuals, groups, or organizations, any psychological service. So again, psychology is being defined as psychology, involving the application of psychological principles. Again, that's circular. And it talks about pertaining to learning, perception, motivations, emotions, and interpersonal relationships. So basically, any conversation that you have with someone that touches upon their emotions, their behavior, their relationships, improvement, like you said, these all potentially fall under the definition of psychology, and the state of California and the Board of Psychology is reserving the right to come in and say, oh, you need a license for that. And if you don't have a license from us, we can come after you. And that's just crazy.
It is. And it actually is crazy that they decided to impose a penalty on Anna because I've talked to other licensing boards, state licensing boards, like state medical examining boards. And a lot of them will say, if someone is not licensed by us, we don't get involved. If they're practicing without a license, they're technically outside of our jurisdiction. Yes, it could be considered a violation of our state law, but that would be more for the attorney general or the district attorney to pursue as a criminal violation as opposed to a licensing board, which is really a lot of licensing boards just view their role as to ensure the people who are licensed are behaving in a way in accordance with the standards that the licensing board has set.
That's not the case here. The Board of Psychology feels entitled to look farther than that.
Yeah.
And it's concerning. For example, I think their definition clearly would apply to things like Alcoholics Anonymous. It would it apply like you said, business consulting, definitely. Generally speaking, giving advice, giving guidance to people trying to make their lives better, like relationship coaches. That's
Mhm.
clearly something that's falling under their definition here. It's overbroad, it's vague, and because of these reasons, it's constitutionally infirm. And because this is content based, this is definitely something that's going to trigger strict scrutiny under First Amendment doctrine, because essentially the government is saying the content of certain conversations here is something that we can regulate. But the Supreme Court has said, in order to do that constitutionally, you need strict scrutiny, you need compelling government interest. They've articulated no interest here yet, and need it to be narrowly tailored. And it's very rare for that kind of speech restriction to be upheld when you do give it constitutional scrutiny in court.
Yeah. Yeah. And I will also add how I even learned about this case. I think I mentioned this before I hit record was that someone in the coaching community alerted me to this crappy childhood fairy situation out in California, and they were scared. They were scared to hear that, oh, the California Psychology Examining Board was taking action against life coaches. And so they were scared about what can I say safely to my clients and as and describing my services, which basically is chilling speech. And that is something I know that the Supreme Court does not like.
Yeah, that's exactly right. That is part of the injury in these kinds of cases. It's not just the person that they come after who's hit with a fine or other penalties. It's the chilling effect, to use the term that the courts use, the chilling effect on everybody out there who decides, oh, I'm actually going to keep my mouth shut now because I'm worried what's going to happen. And that's wrong.
Yeah. And I mentioned that I'd written a couple of law review articles on this very topic, but not on the psychology definition, but I was focusing on the practice of medicine definition, which in a lot of states is also very broadly defined to encompass so much that it's hard to really do anything without feeling like you're practicing medicine without a license, especially as I say in one of my articles, if you use disease prevention as part of the scope of the practice of medicine. Disease prevention, a lot of it has to do with communicating about what foods to eat, what exercises you should be doing, just giving people information and education about ways to live healthy life so that you can prevent disease. And physicians are the only ones who can have those conversations. That's just unrealistic. My point in my article is that those laws need to be scaled back and narrowed and or have carve outs for allowing people to have conversations about how you can eat better to prevent diabetes or heart disease or whatever, and so that the more effective disease prevention can actually occur. Because honestly, physicians are not having those conversations, even though they are the only ones legally allowed to. They're not having them, at least not in the depth and breadth that needs to be that consumers are asking for.
For
So
sure. Pacific Legal Foundation, we definitely agree with all that. We think that more is more. We think that more choices for consumers is better. And we're trying to loosen those artificial and unnecessary restrictions in the healthcare and wellness space when it comes to things like unnecessary restrictions on nurses and nursing practice or midwives, for example. There are a lot of examples of these government imposed bottlenecks on healthcare, on getting these necessary in-demand services to the public. And there's ways that people can help in terms of bringing litigation when constitutional rights are being infringed upon here. But also, there's definitely a role for legislators. And that's also something in that Pacific Legal Foundation that our policy team gets involved in. We do talk to legislatures and try to advocate for these common sense reforms that will open up these opportunities for more healthcare provision.
yeah. And people want it, people need it. And I think you alluded to it earlier. It's not just the right of the speaker that is being injured by these licensing board actions, but also the rights of the listeners who are being basically foreclosed from hearing messages that might benefit them. And I think it's really important to also point out, which I think I do in my articles, is yes, there are people out there who are speaking things that are not correct, not scientifically, and there's no basis in science for a lot of what they say and could cause harm like drink bleach and things like that. But there are laws that do offer protection for misrepresentations and spreading falsehoods and things like that. It's not it's going to open the floodgates and now all of a sudden you're going to have like all these misinformed people. There are legal protections that exist to help kind of rein in some of the grifting and the riffraff that might might also exist in the marketplace.
For sure, there are existing laws that protect against fraud. That's not what we're dealing with here. What we're dealing with is an excessive precautionary principle. I'm sure you're familiar with the concept of the prior restraint. In the old days, before the American Revolution, you needed a license before you could publish anything. You needed the government's permission beforehand. And a core thing that the founding fathers sought to protect with the Constitution is to get rid of this prior restraint. And that's in the context of speech, especially. But that principle kind of applies everywhere. The more prior restraints that you have in society, the more times that you need to ask permission from the government before you're allowed to do something, the less free society is. And I think that the more of those sort of unnecessary prior restraints that we have in multiple different fields, you artificially constrain people from helping one another much
Mhm.
more than you do from harming one another. And that's the real harm caused by things, by these excessive regulations, these draconian actions by boards of psychology or nursing, et cetera, is they are stopping people from doing good.
Yeah. Yeah, and I've encountered enough individuals in the wellness industry where I can say that there's a lot of people out there who are doing it because they want to do good. They're not doing it to swindle or misrepresent or misinform people. They're doing it because they truly believe in what they're saying and the message and that people want to hear it. So again, thank you so much, Christopher, for the work you do, for just being involved in this space. I am so happy that there are other lawyers out there who are believe in wellness, justice, believe in helping shape the wellness field and make it serve in interests better than it does already. And I just want to just offer my thanks to you.
Thank you, Barbara. It's been a real pleasure talking with you. I'm so glad that other people are excited about the case and support Anna and see the larger cause. So thank you very much.
And if people want to learn more about what the work you are doing, can they go?
PacificLegal.org. We've got a
Pacific.
lot of great cases out there. So check us out.
Okay, pacificlegal.org. Thank you so much, Christopher.
Thank you, Barbara.